All right, welcome back. This is the second capsule on the relationship with constitutional law, which is chapter 2 of the book. So you'll recall that we looked at the very beginning of chapter 2 last week. The second capsule, I think, was solely on the beginning of chapter 2, and we'll have everything this week also part of chapter 2, which is, again, the relationship between administrative law and constitutional law. So where we left off last week, we looked at the first step of a test, which is in the residential tenancies case, and we discussed essentially the extent to which jurisdiction can be taken away from the superior court. So you'll recall that the superior court has inherent jurisdiction by virtue of Section 96 of the Constitution. Section 96 of the Constitution says, right, whatever dispute you have a right to go to court by virtue of the Constitution, and therefore the Constitution creates a court for you to go by default because you have to have that right, and that is the superior court. As I said, it's a constitutional court of inherent jurisdiction. Constitutional because it's created by the Constitution, and inherent jurisdiction because it's the default court, and therefore it has default jurisdiction. So anything that's not given to something else than the superior court is given to the superior court by virtue of that inherent jurisdiction. It has power over everything unless you remove something from that, right? As opposed to, as we'll see, other courts which have jurisdiction that is limited and therefore just over the things that are specifically given to that court. And we said that the power that of the superior court is limited in some ways by Section 96 because you have to have a court of inherent jurisdiction. You can't take away everything from the power of that court. And we said that's essentially because if you could do that, the government could take away power progressively and end up redefining a Section 96 court. So for example, the government could create, right, a tribunal for, as my example from last week, car accidents, and then it could create a tribunal for everything civil and then everything criminal, right? And that would be progressively allowed, but eventually you'd have removed everything from the power of the superior court, and you'd still have, by virtue of the Constitution, that court with inherent jurisdiction. But if you take away everything, right, that inherent jurisdiction becomes useless, right? You have default jurisdiction, but if you take away everything, that default jurisdiction is basically nothing. And so there is a protected core of powers of the superior court to prevent the government from doing exactly that, to prevent the government from taking away too much stuff and therefore indirectly redefining what we have as a court of inherent jurisdiction pursuant to the Constitution. And we have a test for that in the residential tenancies case. We looked at the first step last week, and we said that the power of the superior court has to be a power that is exclusive, therefore a power that, right, was not exercised by some other court. If it was shared, it doesn't count as something that is protected and therefore that the government can't take away. And we said that it has to be at the time of confederation. So at the time of, right, the Constitution Act, 1867, whatever was within the power of the superior court is protected. Of course, that can develop somehow, right? The definition of that power might change slightly over time as society evolves. But everything else that developed after is not covered. And as we said last week, that's significant because the role of government has changed very significantly since 1867. And most things, in fact, right, were not matters that would be within the scope of government and therefore would give rise to various disputes that would end up before the superior court at the time of confederation. So the government can create a tribunal for car accidents, as in my example, because there was no law on car accidents back then, right? Same thing for welfare and various other government schemes that developed afterwards. So in fact, that protected core is pretty limited because the role of government evolved significantly after Confederation. So that was the first step, as we said. And we look at the other steps this week. The second step that we'll look at is whether it constitutes a judicial function. Because, of course, right, it is a constitutional court of inherent jurisdiction, and therefore we only protect matters that count as stuff that is exercised by a court. And that depends on, as the book says, the nature of the question. And generally what we protect is, right, some sort of an ability to apply rules, right? That's generally what courts do. They apply rules to specific disputes. That's an adjudicative function that is judicial. And second, something about procedural fairness. So the other thing we protect is generally how these decisions are made. We protect various procedural rights of the parties in reaching these decisions, and that's generally what defines an adjudicative function that therefore is protected pursuant to Section 96 of the Constitution. That's in contrast to, as you're mentioned in the book, other functions that are exercised by governments that often have to do with policy. So often the governments will have to weigh policy concerns in making a decision. For instance, right, a minister might have to weigh various policy concerns in making a decision. That's not an adjudicative function, right? It doesn't really meet these tests and is not what we would traditionally have being decided by a court or as a power being exercised by a court. However, there's kind of an exception, right? It's not called that in the book, but that's maybe a good way to conceptualize it. And that is if the power is merely ancillary to the, you'll see my handwriting doesn't get much better over time, but if the power is only merely ancillary to the tribunal that it is being given to, then you might be able to take away from that core jurisdiction pursuant to Section 96. And that makes sense because you'll recall the first step of the test says it has to be a power that was exclusively exercised by the superior court. Everything else is not protected, and you see that idea of exclusivity here as well. So if you create a tribunal or some other adjudicative body that makes decisions, right, in some way, it could be commission, whatever it is, right, and you have to give it certain powers that fall within the protected core of Section 96, but that is, quote, merely ancillary to its functions, necessary but not central. That's what it means, right? So it's necessary for it to exercise its function, and it's not central to its role, therefore is not meant to replace really the jurisdiction or the role of the Section 96 courts, superior court, then it's allowed. So the government can create that adjudicative body and give it that authority, and it won't, right, be invalidated by the test in residential tenancies. And that's similar to the test that we have for jurisdiction pursuant to Section 91 and 92 of the Constitution, right? So you might have learned that you probably did actually in constitutional law, right, that we have specific powers in Canada granted to our various levels of governments, right? So we don't have a default level of government where as in the United States, for instance, everything that's not specifically granted to one level of government falls within the scope of the other level of government. In Canada, we have enumerated powers for both, and there's no default, right? There's no default level of government that exercises jurisdiction over various issues. Obviously, you have certain areas of jurisdiction which are very broad, like civil issues within a province, for instance, that are naturally going to encompass various things. Nonetheless, it's pursuant to an enumerated area of jurisdiction. In assessing that, we assess whether or not the law is in, quote, pith and substance related to the powers. So, for example, if you have an area of jurisdiction that is of the federal government, it cannot be exercised by the provinces. So the provinces could not pass a law regarding, say, maritime law because that's an area of federal jurisdiction. Nonetheless, that is only true when the law is in pith and substance related to maritime law. So if it's a law about maritime law, then it's not allowed. However, if the law is just indirectly related, then the provincial government might be able to exercise its jurisdiction and indirectly infringe upon the area of protected jurisdiction of the federal government. Same thing here, right? We ask whether that adjudicative function is, right, within the protected court. And then we ask whether it is central to the role of the adjudicative body that we are trying to give it to. If it's not, then it can be allowed even though it infringes upon Section 96. There's also another section of the Constitution which specifically provides for the power of the federal government to create various courts. There are also provincial courts which are created, which remove some jurisdiction from the superior courts, and that's also allowed. So we have statutory courts in Canada, so courts that are created by statutes, laws, as opposed to constitutional courts like the Superior Court, which is created by the Constitution, not a statute, right? And we have those in both the provinces and at the federal level. So in the provinces, for example, right, very recently there was a case of the Supreme Court regarding the Court of Quebec, which has jurisdiction, exclusive to the exclusion of the Superior Court, on disputes of up to, I think, $85,000. And then the question was whether or not that infringed upon, again, the inherent jurisdiction of the Superior Court. If by subjecting all these disputes, up to $85,000, to a different court, you were removing too much jurisdiction away from the Superior Court and therefore redefining it in a way that was constitutionally impermissible. Of course, the history of that was that Quebec kept raising the limit, and at some point, right, people in the bar said it's starting to get too high, and therefore they brought the case. And the Supreme Court said yes. That's an example, though, of a court created by a statute that is provincial, and that's allowed. You also have courts in Canada that are created by statute that are federal, right? Generally, the Supreme Court of Canada, which was created surprisingly recently, again by statute, and that is pursuant to the power of the government under Section 101 of the Constitution to create, quote, additional courts for the better administration of the laws of Canada. And that's what Parliament did when it created the Supreme Court, and also what it did when it created the federal court, which we'll look at in a bit more detail because it has interesting areas of jurisdiction. Initially, it was called, as you're mentioned in the book, page 48, the Exchequer Court of Canada, but then it was renamed the Federal Court, and around the same time, it was also split into two courts, such that it became the Federal Court and the Federal Court of Appeal. You have a number of areas of jurisdiction, and these are provided for in the Federal Courts Act. So you see that it is a court of statutory creation, right? Therefore, you have to have a law that creates it, and that is the Federal Courts Act, which creates the federal court and gives it its jurisdiction. Because it's a statutory court, it's not the same as the Superior Court. It does not have inherent jurisdiction. Therefore, whatever the Act says is what the federal court can do, no more. And so, if you have something and you have to decide whether or not you have to go to the federal court or the Superior Court, you look at the Act, and the various things that are enumerated in there are the only things that the federal court can do because it's a court of statutory creation, and therefore of statutory jurisdiction. So whatever the jurisdiction is in the act is what the federal court can do. If it's not in there, then you know where to go, because there's also that default court we talked about, which is a superior court, which has the opposite, right, the opposite logical foundation, which is it's a court of inherent jurisdiction. So it has power over everything except what is removed. For instance, by the Federal Courts Act, in creating the federal court, you're removing stuff from the superior court, moving it to the federal court. Superior court retains its inherent jurisdiction, therefore has jurisdiction over everything but that. And then the federal court, right, opposite reasoning, has only jurisdiction over these things, never and can never have that default jurisdiction. Main things that the federal court is going to have jurisdiction over are various areas of federal jurisdiction. For instance, things having to do with maritime law or intellectual property, right? Patents, copyright, and all that, right? These are areas of federal jurisdiction pursuant to sections 91 and 92 of the Constitution. They're areas where the federal government has the power to legislate as opposed to the provincial governments. And interestingly, it's also going to have power over essentially the government, the federal government, and that's a pretty broad power. So the federal court is going to have jurisdiction over, first, federal laws, and second, actions against the Crown. And that becomes very relevant in administrative law because oftentimes, right, when you have a dispute that is subjected to administrative law, of course, a tribunal is being created by a statute. And therefore, when you seek judicial review, it might be of an action of the Crown, and therefore you're sent to the federal court. For instance, you have some bureaucrat in the federal government makes a decision not to issue you a license. That's pursuant to a federal law, and it's essentially an action against the Crown. You are seeking judicial review of a decision of a federal employee, federal government employee. Therefore, you have to go to the federal court to seek judicial review of that decision. Same thing if the federal government creates certain adjudicative bodies. So, as in my example last week, right, the federal government creates a tribunal over, let's use patents, which are an area of federal jurisdiction. In fact, there is a patent board, right? And then you seek judicial review of that decision. In that example, it's a decision that's made by something similar to a tribunal, an administrative tribunal, which replaces a court. It's not simply some government employee. But again, you are seeking judicial review, and therefore you have to go to the federal court because it's essentially a decision of the Crown that's made pursuant to a federal law. There are also certain areas, this is mentioned in the book, where you go directly to the Federal Court of Appeal. So Federal Court of Appeal has jurisdiction, of course, over appeals from the federal court, which you don't always have a right to, right? Depending on where you're coming from, you might not have a right of appeal to the Federal Court of Appeal. For instance, immigration decision, that's one of the things that the federal court has power over. Federal government's created, again, an administrative tribunal, created the refugee, if it's a decision regarding refugee protection, there's various types of decisions regarding immigration. So if it's regarding refugee protection, you go first to the Refugee Protection Board, which is a tribunal created by the federal government. So federal government says we don't want these judges at the federal court to make decisions on immigration because they get paid too much. So we'll hire a bunch of people, most of them are not lawyers, we'll pay them $100,000 to make these decisions as to whether or not someone gets refugee status in Canada. So by law, you have to go there, you go to the Refugee Protection Board, and then you're denied your prospective status as a refugee. Then the Act says you have a right of appeal, quote unquote, really it's review, but appeal to the Refugee Appeal Board, which is also a tribunal that is created by, again, the federal government, ostensibly for the same reasons, because it also doesn't want people who get paid $300 grand a year to make decisions on refugee appeals, and so create some other bureaucrat, right, who makes that decision, and you have to go there by statute. Then you keep your right, as we said last week, to seek judicial review of that decision, because it is a power that is inherent to the court. So the government has the right to create these two tribunals to make decisions instead of the federal court. However, because the courts generally, by virtue of Section 96, unless it's delegated, but the courts generally have supervisory power over administrative decision makers. And that's one of your constitutional rights. And so the government can't remove that fully. It can't say, for instance, the decision of the Refugee Appeal Board is final and without appeal. You always have a right to seek judicial review before an actual court by virtue of the court's supervisory power pursuant to Section 96 of the Constitution. Therefore, where'd you go? Because it's an area that's given to the federal court, you go to the federal court. But the federal court exercises a very similar power there, right? It has the same oversight constitutional power as the superior court. The judges are named by the federal government, they're independent, they sit for life, all that, right? And so you go there, you seek judicial review. In that example, you don't actually have a right to go to the Federal Court of Appeal unless you ask for permission. So, Federal Court of Appeal, right? The federal court in that example, is your final decision maker. Federal Court of Appeal has jurisdiction over, first, appeals from the federal court to the extent that they are provided for. So there are certain issues where you have a right of appeal to the Federal Court of Appeal. Then you go there. That's one of the things the Federal Court of Appeal does. Second thing it does, interestingly, is it has jurisdiction over certain boards. For instance, I think the CRTC, maybe the federal government thought these decisions were so important it needed the expertise of the people of the Federal Court of Appeal. And so in these examples, you go directly to the Federal Court of Appeal in seeking judicial review of a decision that is made by an administrative decision maker, in that case, a board created by the federal government. You have the test from the ITO case at pages 52 and following of the book. I won't write it down, and it's not all that important, but it's what defines defines the jurisdiction of the federal court in determining whether or not that jurisdiction has been specifically given to the federal court. So, as I said, has jurisdiction over federal issues and the laws of Canada. And so you have to assess whether or not a dispute is brought pursuant to a federal law or not. And sometimes that's not very easy to tell, right? You might have various laws involved, and some of them are provincial, some of them are federal. And when that is the case, right, you have to assess whether or not it's quote-unquote federal enough for it to fall within the jurisdiction of the federal court. The ability to consider constitutional questions, we'll discuss that in the context of administrative decision makers as well, is a power that can be given to something else than the superior court, which of course again has default jurisdiction over that as well, a constitutional issue, by virtue of Section 96 of the Constitution. So the federal court can be given the authority to adjudicate a constitutional issue, and that's allowed, right? And in that example, it's not particularly scary because it's an actual court, right, where the people get paid the same amount of money. Again, as I said, have the same independence, they sit for life and all that. However, you cannot fully remove constitutional issues from the superior court, again, for the reasons we mentioned, right, because then you'd be redefining the inherent jurisdiction too much and therefore in a way that is right, that negates the very meaning of having inherent jurisdiction in the first place. And we'll discuss how you can do that with administrative decision makers as well. And that's where it gets more scary, because it might be, in my earlier example, refugee protection board, some bureaucrat who gets paid $100,000 who's not even a lawyer. And that person can be given the ability to make a determination as to a constitutional issue, which often will be a charter issue, so an issue as to constitutional rights. And so that person can be asked to decide that, for instance, Section 67 of the Act, right, the Refugee Protection Act, which it is applying, is invalid. We'll see what the actual remedy is. But invalid, quote unquote, because it's not consistent with the charter. And there's a remedy for that, right? It doesn't actually invalidate the provision. But you see, again, a very significant decision being made by an administrative decision maker instead of the court, who does not have the same constitutional legitimacy, independence, expertise, and all that to make these constitutional decisions. And that's one of the reasons why the standard of review is going to be stricter, because again, right, that decision being made by an administrative decision maker is not and cannot be final. You always have a right to eventually go to an actual court and seek judicial review. It applies as well to the example I just gave you. So if that decision maker makes a determination as to a charter issue, you have a right to seek judicial review of that decision before an actual court. So go to an actual court and say, this is wrong. This is a decision that is wrong in law. The decision maker made a mistake. And as we said last week, there's a range of standards being used to assess whether, conduct judicial review that go from more deference to less deference, go from what we call reasonableness to correctness review. Reasonableness, as we said last week, looks at whether the decision falls within a range of decisions that could have been reached. It's very deferential, and the court can be sure that it would have made a different decision, can be sure the decision is wrong in some way, in fact, but nonetheless find it to be reasonable, and often will, right? Almost always courts will find decisions to be reasonable because it's a deferential standard. At the other end of the spectrum, we have correctness review, which is a less deferential standard, where the court will assess whether or not it's the decision that it would have made, whether it's a correct decision, the good decision, based on the assumption that there is, in that example, a right and a wrong decision. And that includes issues of statutory interpretation, issues of law. And therefore, if your administrative decision maker, in my example, makes a determination that something infringes upon the charter, then that administrative decision maker is subject to correctness review because it decided an issue of law, decided whether or not, right, the charter was infringed by the specific legal provision, and therefore that is subject to correctness review. So, in summary, the federal court has power as well over, first, provincial laws in some situations where the dispute is predominantly federal. Second, it has jurisdiction over constitutional issues to the extent that they're necessary. Another thing that we'll look at in a bit more detail later on in the semester is that it has essentially injunctive power. So it doesn't really have as its main power the power to award damages. So it's not the place where you go when you want actual money. Generally, it's the place you go where you want to force the government to do or not do something. So for instance, in seeking judicial review, that's what you're trying to do, right? You might be saying that bureaucrat or that minister made a decision that is wrong or unreasonable, whatever the standard is. And as we said last week, the default remedy is not in administrative law for the court to substitute its own decision for that of the administrative decision maker. The court does not do that, as it would in, say, an appeal. Instead, the court generally quashes, quote-unquote, the decision and returns it to the decision maker for redetermination. And it seems odd, right, because it's not particularly efficient, because then if the new decision maker makes another wrong decision, then you have to go back, it's canceled again, and then, right, you go back, and it goes on and on. But that's because of the purposes of administrative law. That's because the court recognizes that the government gave the power to that administrative decision maker for a reason, to the exclusion of the courts, right? Because it wanted that administrative decision maker to be able to develop a specialized expertise to make that decision in a cheaper and more efficient way, and to be able to make that decision more quickly and all that, right? All of the various areas, the various advantages of administrative law that we discussed last week. So if you had the court substitute its own decision, it wouldn't have the same quote-unquote expertise, and it would also create a perverse dynamic where you could systematically go to a court to seek judicial review and have the decision replaced. And that wouldn't meet the government's intent to have a dispute decided by something else than a court if the court makes the final decision. And it also would add cost to the system, right? Whereas having that decision returned, right, without the court making a determination of fact or having, right, the record, looking at it, more quickly returns it back, and that decision is made again in a way that's theoretically cheaper and more efficient. So we'll take a virtual break on that, and then in the next capsule we'll define more specifically the extent to which an administrative decision maker has the power to make a determination as to a constitutional issue, which, as I said, often means a charter issue.